Hello, Greg Brown. I'm with the law firm of Brown and Charbonneau. Today I'm going to talk about the difference between mediation and arbitration. Both are options to resolve disputes without judges and juries, but they are somewhat different. They're known as alternative dispute resolution, or ADR, but mediation and arbitration are the two most common. So first let's talk about mediation. Mediation is a voluntary process. It's an agreement between the parties to get a third-party mediator together with them to help them try and resolve their dispute. The mediator's role is to allow each side to voice their opinions and desired outcome and to help try and find a consensus or a compromise to work out their dispute without going to court and incurring all that time and expense. The parties, though, do need to be willing to cooperate and try and work together. This isn't a situation where the mediator makes a decision or whether there's a winner or loser. It's a way to try and work through the dispute and come to some form of mutually agreeable resolution. Now, keep in mind with a mediation, if it doesn't work out during the process, either party is completely allowed to just walk away and move on. It's not a binding process of any sort. Now, the other form that's most common is an arbitration. And an arbitration is a situation where you have a trained arbitrator that will hear the case. It's similar to a trial, but it's usually in an informal setting, say a conference room or some other place in an office. Although it is informal, usually the procedure is like a trial where both sides would submit briefs beforehand. They'd both do opening statements, maybe, but then certainly you put on evidence where both sides testify before the arbitrator. With each arbitrator, the process as far as how formal or informal it is will vary. Now, if it's a binding arbitration, the decision is final, and any appeals or other options beyond that are very limited. But the benefits of arbitration, and specifically binding arbitration, is that it typically costs less than traditional litigation. It is private, so the filings don't go into the public record, and it's usually quicker. Now, in one of our next sessions, we'll talk about the different varieties of arbitrations, and we'll also talk about how to prepare for mediation. Thank you.